So just just also to say, Northamptonshire Rights and Equality Council, we're a local charity. We do discrimination advice, immigration advice, and hate crime support. Um, and this briefing is specifically for voluntary sector agencies to try and support local voluntary and community sector to have the best practice in terms of working according to the law, but also working with their communities. This hasn't been designed as a workers' rights briefing, but obviously we are concerned about workers' rights. But this is more about an empowerment for community organisations to have good practice. And for those amazing people who have signed up for this session, we're very grateful that you can attend. And we're going to be emailing you at the end of the session a copy of the presentation, a copy of a briefing note, which is slightly more than 1 page of A4, but it shouldn't be too arduous to get through, and 2 tools, one a template risk assessment plan and a template wording for a poster in case there was more proactive work you might want to do over this. So I'm just going to share my screen for the presentation and we'll kick off. And this is really whistle stop. If we're trying to do this we're trying to do this so that it's in a short period of time, but hopefully you get the most out of it. So just to say, so what does the law say about harassment? This is about this new legislation that came into force on the 26th of October. It was introduced into Parliament in January for enactment on the 26th of October. And it's an amendment to the Equality Act. And it is around harassment related to a relevant protected characteristic, including sexual harassment and less favourable treatment of a worker because they submit to or reject sexual harassment or harassment related to sex or gender reassignment. So the protected characteristics it relates to are just age, gender reassignment, religion or belief, sexual orientation, disability, race, and sex. So the ones that were left out, as it were pregnancy and maternity, and some of that, if someone experiences harassment relating to pregnancy and maternity, they can often do kind of pursue a course through sex. And the other one is marriage and civil partnership, but those were the 2 that were, as it were, left out. So what's the essence of harassment? Examples of it would include spoken or written words, posts or contact on social media, imagery, physical gestures, facial expressions, mimicry, jokes or pranks, acts affecting a person's surroundings, or physical behaviour towards a person or their property. And the key issue is that it's unwanted or unwelcome or uninvited. So those are these key words within this legislation around harassment. So I thought we'd look at a few examples. Now, what I've done is taken a lot of the case studies. So I've gone through the Equality and Human Rights Commission Code of Practice on this. They've got some quite useful case studies that kind of bring it to light. So the first one they're suggesting relating to sexual harassment is if a male line manager was to interview a female worker for a promotion, the manager says that the interviewee is the favourite for the job because she's the best looking candidate. The manager's statement is self-evidently unwanted, and the worker doesn't even need to object to it for a tribunal or court to find that it's unwanted. we'll go on to another one in relation to homophobic harassment. So a male worker is called several homophobic names by his colleagues who know that he is heterosexual. However, an employment tribunal finds that this worker did not object to the conduct, which continued for several years, and he even willingly joined in, making it equally offensive comments to his colleagues. There's also evidence of genuine friendships with the colleagues, such as going on holiday with one of them, and a tribunal in this circumstances would find that the worker's actions don't indicate that conduct was unwanted. There's a variation of that in one of the other examples from the EHRC Code of Practice, and this is, with that previous example, the colleagues use very offensive homophobic terms about the worker in an in-house magazine. This is read by a much wider group than the immediate group of colleagues. And in these circumstances, the tribunal accepts that this article goes beyond what the worker had previously deemed acceptable and therefore was unwanted. So it does make a difference in terms of the breadth of exposure to unwanted harassment. So here's another one in relation to faith or religion. A Sikh worker wears a turban to work. His manager wrongly assumes that he is Muslim and subjects him to homophobic abuse. The worker could have a claim for harassment related to his religion and belief because of the manager's perception of his religion. So again, with this harassment amendment, the kind of less favorable treatment on the basis of perception is good enough to pursue a claim. And another one, a manager racially abuses a black worker in front of a white colleague. The black worker has a clear claim for harassment related to race. In addition, the black worker's white colleague is offended and could also bring a claim of harassment related to race. So this, again, one of the constructs of the Equality Act, harassment on the basis of association. So other examples of sexual harassment, things like comments and jokes, sexually graphic pictures, posters, suggestive looks, staring and leering, propositions and sexual advances, making promises in return for sexual favours, intrusive questions about a person's private or sexual life, or a person discussing their own sex life, sexual posts or the content in social media, spreading sexual rumours about a person, and spreading sexually explicit emails or text messages, and unwanted welcome touching, hugging, massaging, or kissing. So going back to the civil law definition of harassment, it is this violation of dignity or creation of an intimidating or hostile, degrading, humiliating, or offensive environment. And the key things about harassment, it does not have to be repetitive. One single act of harassment, should it be extreme, could be enough for a claim to take place. And also, as we've seen in the case studies, it is a perception definition. So the person who is on the receiving end of the harassment, it's their judgment and belief about whether there has been a violation of dignity or whether conduct or actions are being intimidating, hostile, or degrading or humiliating. So it's really important to remember it is that perception definition. So who's covered? So the people who are covered that employers have a duty to prevent harassment against is job applicants, contract workers, agency workers, people who are consultants, partners, members in things like a limited liability partnership, personal and public office holders and those undertaking vocational training. So it's a very wide range of people that employers have this new responsibility to prevent harassment. So this prevention is referred to as this preventative duty, and employers must take reasonable steps to prevent sexual harassment of workers in the course of their employment. So the consequences of not taking action potentially are the Equality and Human Rights Commission taking enforcement action against a specific employer. But also, if there hasn't been prevention or action of this preventative duty, if an individual succeeds in a claim of sexual harassment and is awarded compensation, an employment tribunal can consider that the employer, if they consider that the employer has not complied with the preventative duty, they can increase compensation by up to 25%. So what does preventative duty actually entail? So what they'd be looking for is specifically that there is a harassment policy. It may be that your workplace or your employer already have a harassment policy, and this may be sufficient. It would be helpful if the harassment policy made reference to the preventative duty, but having a policy is probably a good starting point. The next thing is unless an employer has put together a risk assessment on the preventative duty, a tribunal will be unlikely to believe that they have taken sufficient action. So that would be a real essential core of an activity around the duty to prevent sexual harassment of workers. But there are other things that can be done that include things like being proactive, having one-to-ones, doing surveys and exit interviews, and also things that critically monitor and evaluate your policy. So employers must take reasonable steps to prevent this sexual harassment in the course of their employment. What they need to try and influence is not only other people in the workplace, such as other workers, but also contractors, volunteers, particularly in voluntary organisations, but also third parties such as clients, service users, and customers. So this is why it would be helpful, again, if you're trying to influence clients, service users, or customers, to have things like posters clearly stating the approach of the employer relating to harassment. And that's why we're giving you potential texts of posters that you could use within a workplace to demonstrate being proactive in the duty to prevent sexual harassment and the preventative duty. So in terms of the risk assessments, an employer needs to be considering the risks of sexual harassment occurring during the course of employment. So they keep on using this course of employment phrase. It's actually a phrase which our organisation has had a long link with, because it was one of our cases that actually got that enshrined into case law. So it means not only during working time, but maybe during breaks, during events that happen outside of working hours that are work related. So it's about the employer considering the risks of the sexual harassment, considering what steps it could do to reduce those risks and prevent sexual harassment of workers, and consider which of those steps will be reasonable to take and to implement those reasonable steps. So critically, again, it means this carrying out a risk assessment. Obviously, it will require some resource to kind of try and address things that come out of the risk assessment. But what any court or tribunal would do is look at what steps are reasonable, and finance can come into it. So things like expecting something that was very kind of investment heavy in terms of cash for a small organization may be considered as reasonable not to invest back, but you have to be thinking about other things that you could do to mitigate that risk. So just to say about our work, if you come across people experiencing any kind of harassment, we offer support in terms of our work related to hate crime, but also in terms of harassment in the workplace. Please, you can refer people to us, and we're happy to assist in that. We're also happy to see whether we can do more in relation to this in terms of training with service users or maybe a workforce, and that's something that you can get in touch with us about. I think it's also really critically important to look at the, aside from the legal aspects of this, the kind of impact on harassment on well-being as organizations that work in the community. We obviously care about people experiencing the impact of harassment, but it can have that wide range of experiences that include isolation, feeling insecure, feeling unheard, being concerned that you wouldn't be believed, being frustrated and anxious about it. There's more to consider in terms of often people maybe will be concerned about reporting harassment because they're not they don't think they're believed. And critical to emotional well-being is ways of to access ways of managing this anxiety. And again, we're happy to maybe consider additional training if people would like that, and please get in touch if you would like that. And I've just got a last slide around other sources of support in terms of other organisations such as ACAS in relation to information and advice for workplace relations, citizens advice, obviously the Equality and Advisory Support Service, which gives one-off advice. And I think the other thing I'd draw attention to is particularly the last couple. Firstly, the TUC, who provide a really good toolkit around sexual harassment in particular, and also Rights of Women, who are an organisation we've been involved with in the past, who provide us free sexual harassment at work advice line. So that's the end of that particular aspect of the presentation. I'm just going to stop the recording.